Thank you all for joining us. I'm Pam Metzger. I'm the director of the Deason Criminal Justice Center. And today is one in a series of our STAR criminal justice events. That's for STAR, stands for Small, Tribal, and Rural. And I'm so very excited today to have you join us for a conversation with Mary Kathryn Nagle. Mary Kathryn is an enrolled citizen of the Cherokee Nation. She's a partner at Pipestem and Nagle Law, where her work really does concentrate on tribal sovereignty and the inherent right of Indian nations to protect their communities, and particularly their women and children, from domestic violence and sexual assault. Mary Kathryn has a lot of different hats that she wears. I first got to know her at Tulane Law School, where she was then law student slash playwright. And she's graduated from that to be lawyer and advocate slash playwright. Many of you may have seen the profile the New Yorker did about her and her work. On the legal side, she has really significant experience in constitutional law issues relating to Indian law, Indian sovereignty. She's prepared for and litigated cases in courts across the country, as well as in state and federal courts dealing with sovereignty. She's clerked in the federal district courts and in the Fifth Circuit Court of Appeals. And that's just with her legal hat. And with her playwriting and storytelling hat, she's an alum of a 2013 public theater program for emerging writers. She was the first executive director of the Indigenous Performing Arts program at Yale. And she has written and produced several plays about Indians and the law, including My Father's Bones with Susan Harjo, Ms. Lead, Fairly Traceable, and Sliver of a Full Moon. And I'm not giving full credit to here to the rather fabulous play she wrote about what happened in New Orleans after Katrina. So with that introduction, I'd like to welcome Mary Kathryn Nagle and say hi. So nice to have you.
Hi, thank you so much for having me. It's great to be here.
So there's so much I want to ask you about, but I think I'm just going to start by asking you, particularly because we have lots of law students joining us today. How is it that you get to be a lawyer and a playwright at once? Most of us would like an answer for how you've navigated that.
It's very challenging. It's a blessing that it's a challenge. It's a challenge because I do have plays that are getting produced, and I do have commissions with theaters. So, initially when I was sort of working as a playwright in law school, for instance, I wasn't having plays professionally produced. It was, maybe perhaps a bit of a hobby that I loved and was very near and dear to me, but it wasn't a career. I didn't have to report any income to the IRS, certainly. If anything, I lost money being a playwright. And now I'm very fortunate to have plays that are professionally produced. And it's such a blessing, but it's also very time consuming. And so, and anyone who's a lawyer knows that job is also very time consuming, hectic, all kinds of last minute briefings and motions that you don't always anticipate. Sometimes your clients come to you and, someone has filed a lawsuit against them and they've failed to tell you, and that you have 5 days until the answer's due. And you never know what's going to happen in litigation. And it really keeps you on your toes. And so, I would say really it's become, again, it's a blessing to have these problems, because I love the work that I do as a lawyer, and I love the work that I do as a playwright, but it does require some real, I have to really prioritize and manage my time. And I have to really schedule myself and schedule times to be writing, whether it's writing a brief or a play, and really be mindful of how I'm spending my time, which, a lot of people do. People who work full-time and are parents have to do the same thing. People who work full-time and they're taking care of an aging parent or someone else in their life, have to deal with time management. So, so it really it really comes down to time management. But I'm just blessed that sort of everyone I work with on both sides of the aisle, whether it's theater or my legal career, really understand why I do both and support that. So I've had a lot of support to be doing both as well.
So that leads me to the next question I have for you, which is, what is the thread that ties them together. And you and I've talked about this a teeny bit, right? There's storytelling, but there's also the kinds of stories you're telling. And I know that relates to the work we're going to talk about today.
Yeah, so I really like to focus on plays that relate to issues of law. I'm very interested in legal issues, and with a strong interest too on environmental law, but also federal Indian law and tribal sovereignty. And so, if you look at my plays, a lot of them deal with either environmental legal questions or tribal sovereignty, or both. In fact, many of them deal with both. And I've also written some plays too about violence against women, Native women. And so I've been writing about that as well. And of course, that relates to tribal sovereignty as well. And I think what, probably one of the briefs that I filed that best sums it up is actually the brief we filed in the Standing Rock litigation on behalf of my client, the National Indigenous Women's Resource Center, where, here you've got this environmental case. It's really a tribal sovereignty case, because the tribal nation had a right to be consulted. This was their historic treaty lands. They had human burials and sacred sites in the path of the pipeline. And so there are federal laws that protect those. Those, of course, were not respected in the instance of Dakota Access Pipeline. And so when the Standing Rock Sioux tribe was filing a lawsuit against the Army Corps to stop the construction of the pipeline, my client, the National Indigenous Women's Resource Center, asked my firm to file a brief explaining how the Army Corps' permitting of the pipeline to cross the Missouri River didn't adequately take into consideration the public health and welfare. And if you look at the regulations, the Army Corps is required, before issuing a permit of this nature, to consider public health impacts and public welfare impacts. And we were able to show through documented evidence that the rapid increase in extraction of oil in Western North Dakota and what is known as the Bakken, the very rapid increase of extraction from like 2005 and on, in the 2000s, had led to a rapid increase, an extreme increase in violent crimes being committed against Native women and girls. And so what we were showing is a case that's really about environmental law is also about safety for Native women, and a case that's really about tribal sovereignty is also a case about safety for Native women. And I think for tribes, we understand that our women are sacred, right? They create the next generation of citizens. We would not have tribal nations without our women. They are life givers, literally. And traditionally, we understand that they're sacred, and traditionally, we work to protect them. And of course, Native women today suffer the highest rates of violence in the United States. So a lot of my work, both in theater and in legal work, has focused on that. And it is nice that the two, because I also wrote a play about what happened to Standing Rock. So, the two do overlap quite a bit.
So let's dig in a little bit on these questions about sovereignty and safety and their nexus. And let me start by asking you if you could give kind of a brief overview of how you understand the meaning of sovereignty for tribes, and then kind of maybe comment a little bit on the perhaps more cramped understanding that some jurists have.
So, it's interesting. I tried to define tribal sovereignty in my play Sovereignty, which is all about my grandfathers, Major Ridge and John Ridge, who were leaders of Cherokee Nation, along with Chief John Ross, who all worked together for decades to preserve the sovereignty of Cherokee Nation. Most people today know about the division between these two, what became a division between these two political parties, but and the play does cover that, but it also focuses on the harmony and the collaboration they had for decades, which was powerful. And before the division, which was largely caused by Andrew Jackson and other outside forces that were trying to destroy Cherokee Nation. And so in that, there is this discussion because they're fighting to save not just Cherokee Nation's homelands, but also the inherent right of Cherokee Nation to govern. If you look back at what was happening at that time in US history, Georgia was passing a series of laws making it illegal for Cherokee Nation's government to function, saying, we will arrest anyone who tries to exercise governmental functions of Cherokee Nation. Your government is illegal. So we had to move our capital from what is now Georgia to what is now Tennessee so that our government wouldn't be arrested. They made it illegal for non-Indian American citizens to come onto Cherokee Nation land without the blessing or permission of the Georgia governor. They did all kinds of things that infringed on Cherokee Nation's sovereignty. They tried to shut down, and did succeed for a bit in shutting down our newspaper. And so, it really does bring about this question of like, what is sovereignty? Clearly, it's the inherent right of a nation to govern itself. But it's also for Native people a lot more than that. And I've heard many elders and Native activists say, for instance, when I speak my language, that's sovereignty. When I've heard tribal leaders in the Pacific Northwest say, when I go and fish in the same river that my ancestors fished in, and I get to fish there because of the treaty they signed with the United States, that's sovereignty. I think when tribal nations are able to protect their own women in their own homes from domestic violence, rape, sexual assault, homicide, that's sovereignty. When our tribal council passes a resolution at Cherokee Nation today, that's sovereignty. When our Cherokee Nation Supreme Court issues a decision, that's sovereignty. Just like when the United States Supreme Court issues a decision, the Supreme Court of France has no say over United States federal law. That's our United States Supreme Court. The courts of China have no sovereign jurisdiction over legal matters within the US, right? That's our US courts. So the same thing with our tribal nations. Our sovereignty is our inherent right to govern ourselves.
And for those, we've got an audience with a variety of different levels of understanding. After many, many years of, I think, less than ideal, perhaps, litigation over the clarity of boundaries and sovereignty, right? We have this very unusual and I think surprising decision in the McGregor decision. Were you surprised by McGregor?
Yes and no. I think a lot of us practitioners of federal Indian law are used to losing cases. We've lost a lot of cases, not because the law wasn't on our side, but because, to be quite honest, many of the cases in the last 60 or so years from the Supreme Court have been quite outcome determinative in terms of disestablishing sovereignty. And so that was the surprise. But I also think anyone who read Justice Gorsuch's decisions while he was on the 10th Circuit understood that he really respects sovereignty. He's studied it. He sees it as an intellectual manner that deserves respect and care and careful thought and intellectual rigor. And to be quite honest, we have not had a lot of justices on the Supreme Court who have treated it that way. I think before Gorsuch, probably the justice who approached it with the same level of respect would be Justice Sonia Sotomayor. And so now the two of them together, and they sit on different sides of the aisle, it's an incredible thing to have in the Supreme Court. Because truly tribal sovereignty is not a bipartisan issue. It shouldn't matter whether you were appointed by a Republican or Democrat president, because the US Constitution says that treaties are the supreme law of the land. That's what the Constitution says. So all justices should be able to recognize that. But the way in which Justice Gorsuch wrote this majority opinion, I would say was stunning for many of us in Indian country, and it's infused a new energy and a new source of inspiration for all of us practicing Indian law. That when our tribal sovereignty is on the line, when we go up before the Supreme Court, it's not going to be some whimsical decision that's detached from the law and is outcome determinative. We've got justices up there who are taking a hard look at this and actually applying the law and doing it with great care and precision. And that is a reason for us to celebrate, for sure.
So I agree 100%. Of course, the question becomes then, what does it look like afterwards? And we've done a couple of programs already at the Deason Center on things like how McGregor is going to affect federal criminal practice, right? And the hundreds of thousands of people who are trying to undo their convictions in state court, which may or may not be a wise decision, parenthetically, right? But I know we were going to talk, and what you're really focused on and passionate about among your other passions is the relationship between sovereignty and safety for Native women and girls. And for folks who aren't perhaps familiar with the issue, while interpersonal violence is a problem for women and girls across the country, Indigenous women and girls are violently victimized at much higher rates than women of any other race, ethnicity, or demographic grouping you can think about. By some studies I've seen, it's 4 out of 5 women who are Indian have been violently victimized in their lifetimes in some way, shape, or form. And yet the data are sparse. It's very difficult to get law enforcement to track, locate, document, much less investigate, identify, and convict perpetrators. And in fact, even the data that we do have is woefully inadequate to capture the scale and scope of the problem. So I guess at the very beginning, let me just ask you, what does what sounds like a case of bad policing have to do with sovereignty, right? How do we translate those facts into a problem of sovereignty?
Gosh, just yesterday, I'm here at the Reservation Economic Summit and the National Indian Gaming Association conference here in Las Vegas. And I was very honored yesterday to speak on a panel regarding missing and murdered Indigenous women and girls, along with current NIGC Commissioner Jeannie Hovland and Abigail Echohawk. And Abigail Echohawk she's with the Urban Indian Health Institute, and she's done incredible work documenting the data problem. And it is a problem. It is directly tied to tribal sovereignty. And here's why. In 1978, the United States Supreme Court eliminated tribal criminal jurisdiction over non-Indians. That's a decision called Oliphant versus Suquamish Indian Tribe. It's had devastating impacts on tribal sovereignty and the ability of our tribal governments to protect our citizens in their own homes. Imagine if here I am, I'm in the great state of Nevada. I'm not a citizen of Nevada. I don't get to vote in Nevada elections. But if I decided to kill 5 people while I'm here in Nevada, it would not be a plausible argument for me to say, oh, Nevada can't exercise jurisdiction over me because I'm not a citizen of Nevada and I don't get to vote in their elections. There might be other defenses I could raise, but that certainly would not be one. Well, that was kind of the basis of Chief Justice Rehnquist's decision in Oliphant was, I don't know if we should let tribes exercise jurisdiction over non-citizens who come into their borders and commit crimes. Insane, because if you said that to any of the states in this country, they would have massive public safety crises because people in neighboring towns on across borders would find out, hey, I can cross this border and commit a crime and no one can prosecute me. That's exactly what's happened. Now, the U.S. Department of Justice has documented some of the rates of violence against Native women, but a lot is not documented. And herein lies the real problem. When we're trying to express to Congress or to the courts or to you name the decision maker in a position of power, just how serious this crisis is, this lack of jurisdiction. There's the response is always, well, we don't see the data, we don't see the problem. And that's because a lot of our Native women and girls who are abused or murdered, their crimes are not reported as a Native victim, especially in urban areas where as the Urban Indian Health Institute and Abigail Echohawk have reported, a lot of the crimes are, they'll report Black or white victim, and that's it. And so when we try to when we try to say this is a crisis and we really need to resolve it, we're told, well, we just don't have enough data to understand the crisis. Or in some communities, border towns to tribal reservations. So for instance, case Sarah Stops Pretty Place's case, I represent her family. She was a citizen of the Crow Nation. She was murdered in August of 2019. And the Bighorn County Sheriff's Office, who has jurisdiction just off the reservation there, labeled her, at first told the family, well, these Native kids out there, because she was 18, they said, she just died from a drug overdose. We know these Native kids just take too much drugs. And then the toxicology report came back and showed no drugs in her system. And so then they said, oh, well, we think she just died of natural causes. And she just, laid down in this yard and her body decomposed for 5 days. And then finally someday, that 5th morning, someone found her body there at this busy intersection in a suburban neighborhood where cars are constantly driving past. Her body was just there for 5 days and she died of natural causes, which is actually impossible. It's clear there was foul play, but they've labeled that not a homicide, but just a natural death. So that there is the problem with data, is that we don't have our own control over the data, and a lot of the data is mischaracterized or just absent. And so in trying to advocate for legal changes that we need to restore tribal sovereignty or to hold federal and state law enforcement accountable for the crimes that they're not actually investigating or prosecuting at this time, it has been very challenging to be able to articulate exactly what the problem is, because again, we keep being told, well, we just don't have the data to back it up. All of your stories are anecdotal, even though if you go to any tribal community, I can't think of a Native family who hasn't had a relative that's been missing or murdered. It's just a fact of life in Indian country, unfortunately.
So, I'm thinking of two terms that I'm sure you think about all the time in your work, which is colonialism and erasure, right? That the effect of what I hear you saying is that the effect of depriving tribes of sovereignty, right, has been simultaneously to deprive them of the capacity to do this work themselves. And yet the government of the United States is not doing it. So you have erasure of the data that would show the problem that needs solving. Is that kind of a right way of stringing those things together?
Yeah, absolutely.
So let me stop before we go any farther and ask you a question about vocabulary that you and I've talked about before, but I think our audience might want to hear. In this conversation, we've already used the words Indian, Native, Tribal, and Indigenous. I think a lot of people are really anxious about those terms. Don't know which ones are right, which ones are wrong. What terms do you prefer? Why? And what are your thoughts about it?
It's a great question. And, I know the term Indigenous has become incredibly popular lately. And I think it's a great term, but a lot of our terms have very specific definitions and connotations. And so, and first and foremost, I'll just say that for a lot of Native people, we like to be considered first and foremost who we are in terms of by our nation. So I'm Cherokee, right? Before being Indigenous, I'm Cherokee, just like someone who's from, um, you know, the Standing Rock Sioux tribe would say, well, I'm Dakota or Lakota. Right? First, that's your identity. But we always have a need to oversimplify things in vernacular. And because Natives do in the larger cultural sense of the American society get lumped together as a racial group, even though we're incredibly diverse from tribe to tribe. When we get lumped together as a racial group, people will say, well, do I say Native? Do I say Indigenous? Do I say First Nations, American Indian, Indian? What do I say? And I think a lot of people say Indigenous, and that's fine and great. And it's a term that's gotten a lot of support lately. I'm a little bit old school, and I like Native. I just do. But I know Native American is not considered the most PC. I'm not offended by Native. There might be some people that are, and if they are, I would let them speak for themselves about how they find that offensive. I can't really speak to that. I do know that Indian is a term that has a very specific meaning under federal Indian law. It is defined, if you look at different acts like the Indian Child Welfare Act or many others, it is in most instances a citizen of a tribal nation. And so it is what the Supreme Court has described as a political classification, just like anyone's my status. Nowadays I live in the state of Virginia, so I am a citizen of Virginia. You might call me a Virginian, but that is a political classification. It is not a racial classification. And we actually have within our nations people who are all different races as well. For instance, within Cherokee Nation, we have Cherokee freedmen who are just as much a citizen of Cherokee Nation as I am. And racially, we might look very different, but we're both Indians under federal Indian law. We're both citizens of tribal nations. So it's, and then I know folks in Canada use First Nations, and I think that's a great term. And I think to me, Indigenous does refer to sort of the fact that, like, when we think of American Indian or Indian within the United States, we're really thinking of citizens of tribal nations. Indigenous to me implies a broader term of like worldwide indigeneity, right? Like, because we've got lots of Indigenous folks, Uh, Indigenous folks were not just within the United States borders, right? I mean, we've got Indigenous folks in what is now Canada, in what is now Mexico, everything's Southern, Indigenous, and all Indigenous to this land. And so I think too, it is important to think about that as we have discussions today about the political realities of immigration. I think a lot of times, unfortunately, our conversations can be a little short-sighted in the United States today. And I think we neglect to note that a lot of the people that we're referring to as immigrants are actually people whose ancestors were here long before our current president, our previous president's ancestors, or many other Americans' ancestors. And so I think it's just helpful to remember that.
Thank you for that. So I suppose since we're talking about a legal problem, let's stick maybe with missing and murdered Indian women and girls, because it's a jurisdictional problem, right? Which makes it a federal law problem. So in the context that we're talking about, what potential has McGirt kind of cracked open for reclaiming sovereignty in the ways that will help assure safety for Native women and girls?
This is a great question. So McGirt is a decision that affirms and upholds tribal sovereignty. And that's huge because, as I explained before, tribal sovereignty and safety for Native women go hand in hand. When our tribal sovereignty is eroded, safety for Native women is compromised. When it's affirmed and upheld, our safety for Native women wins a victory. And specifically, if you look at just the real, like if you want to get just specific, very detailed about it in a legal sense, the definition that was at issue in McGirt was a statute called 18 USC 1151, where Indian country is defined. And Indian country is a legal term that has a very specific meaning, and it means various things, but it does include reservations that still exist, as well as allotted lands. If you look at the reauthorization of the Violence Against Women Act in 2013, when Congress reauthorized VAWA and restored a portion of tribal criminal jurisdiction over non-Indians, in that reauthorization, Congress tethered that restoration of jurisdiction to crimes committed by non-Indians in Indian country lands. Makes sense because that's the larger way in which we understand where tribes are able to exercise their jurisdiction and sovereignty. It's their Indian country lands. What does that mean? That means if a tribe has a reservation, they exercise jurisdiction and sovereignty over certain legal issues within the borders of the reservation. If that reservation has been disestablished, however, their Indian country lands are only going to be those lands that remain in trust status, that have not been removed from trust status and are not non-Indian fee land. If you look at our reservations in Oklahoma, the vast majority of them, the percentage is high percentage non-Indian fee land. There's a real history behind that of dispossession, violence, murder, to folks, as people are now beginning to understand with Martin Scorsese coming out with a movie soon, happened to the Osage Nation. It happened to my nation, Cherokee Nation. It happened to Muskogee Creek Nation. We had a lot of dispossession of tribal lands. And so if, let's say, Creek Nation had lost this case, right, and the Supreme Court had defied the last 100 years of precedent and said, you know what, forget the fact that Congress has never disestablished this reservation. We're going to change the law, and we're going to say the courts have this authority that exclusively before was only Congress's authority, and we're going to disestablish Creek Nation's reservation. Thank God the Supreme Court didn't do that. But if they had, then Creek Nation would no longer have its reservation. And in terms of implementing VAWA, which is a statute that Creek Nation has implemented, when a Native woman within Creek Nation's borders calls 911 because she's being abused by a non-Indian partner or spouse, Light Horse Police, the police force for Muskogee Creek Nation, would have to ask her, what is the status of the land you're standing on? Because if it's in trust, then they have jurisdiction. If it's not, they don't have jurisdiction because of Oliphant. And because our fix to Oliphant right now is just VAWA 2013. And if you recall, that restoration is limited to crimes committed in Indian country. And without that reservation, your only Indian country land is trust status land. And I can tell you that when that's the issue, it is incredibly complicated. And the people who suffer the most are our Native victims, because law enforcement has to, and I mean, it gets very convoluted very quickly, these jurisdictional issues. So, and at the same time, stripping the ability of our tribal nations to protect our own women within the borders of our reservation is a huge aspect of sovereignty that is absolutely critical.
So I'm reminded, I guess as you're talking, I'm thinking about two different things. I'm thinking one, about what it must be like in the moment of an assault, right? To be asking for help and to have someone come back to you with legal questions, which is what they are, jurisdictional questions, right? And to expect people at what is often the worst moment in their life, right, to be able to correctly answer complex questions that often wind up in the United States Supreme Court as a precondition of asking for help. I mean, I think we can start there in understanding what the impacts of colonial erasure of sovereignty might mean, right? That just even asking for help becomes a legal morass. And I'm curious how much of the sense that somehow tribes aren't capable of engaging in that protection, right? This kind of legal predilection to thinking that there have to be certain terms and conditions under which a nation is allowed to exercise that sovereignty. How much of that comes from the narratives that we as a nation historically, right, have told ourselves and sold ourselves about who, and here I'm going to use the word indigenous, who indigenous people within the boundaries of the United States are and what their capacities are, because I imagine that they have to be closely tied.
Absolutely. I think that's just such a great question, because that is the real challenge that we have before us today is deconstructing the prejudice that exists against our tribal governmental institutions, whether it's our tribal defense attorneys, our tribal prosecutors, our tribal court judges. There is a prejudice that somehow these folks, I guess because they're Native, are just simply not as capable as folks who are non-Native and who work in state courts or federal courts. And, I will say I've sat through the oral arguments, for instance, in the Dollar General case, which was a December 2015 case where Dollar General made the argument, hey, Supreme Court, you eliminated tribal criminal jurisdiction over non-Indians in 1978 in Oliphant. Now it's time to eliminate tribal civil jurisdiction over non-Indians here in this case. And by the way, that case was a case where their non-Indian store manager in their storefront on the Mississippi Choctaw Band of Indians reservation had on multiple occasions sexually molested a Choctaw child. And the child's parents were suing Dollar General in tribal court for negligent supervision of their employee who was sexually molesting a child on the job. Dollar General's argument was, well, the tribe doesn't have jurisdiction over us because clearly the Supreme Court needs to extend Oliphant to civil jurisdiction from criminal. So one of the arguments they used during oral argument was to tell the Supreme Court that tribal courts are just not equipped to fairly adjudicate the rights of non-Indians. They did not cite a single example that they knew of or a shred of evidence of any non-Indian not receiving fair treatment in a tribal court. Now, I'm sure this evidence is out there because we're human institutions, just like there are state courts and federal courts that mistreat their defendants, right? I mean, how many people of color has the state of Texas wrongfully accused of homicide that actually didn't commit the homicide? And now we've been able to use DNA testing to show state of Texas got it wrong. But is anyone arguing to the Supreme Court that Texas should be stripped of any criminal jurisdiction over people of color? No, clearly reform is needed in states where people of color have been targeted for crimes they didn't commit unfairly targeted, that is, but what I bring this up to say that, states and federal courts are up here, even though they do have prejudice in their human institutions. They do make mistakes. People who are innocent do go to jail. And yet tribes don't even have to make a mistake. And our integrity is just called into question because we're tribes. And that is inherently, I think, racist, actually. If you look back at the history of this, my great-great-great-grandfather, Major Ridge, was the speaker of our tribal council in 1825 when we created our Cherokee Nation Supreme Court. We opened the doors to our Supreme Court 20 years before the state of Georgia did. But what were the arguments Georgia was using to forcibly remove us? That we were uncivilized, heathens and savages who didn't know how to govern competently because we were not civilized. Our court wasn't legitimate the way the state of Georgia was, even though Georgia didn't have a Supreme Court yet. So those arguments haven't gone away. They're still very much present in American society. And I think it's just up to us to continually educate folks on who tribal court judges are, who tribal defense attorneys are, who our tribal prosecutors are. That these are people who go to ABA accredited law schools. In fact, I was one of my dear friends, Brenda Tonita Pipestem, I was watching her sit on a panel once. She sits on the Mississippi Band of Choctaw Indian Supreme Court, the court that was whose legitimacy was questioned before the United States Supreme Court. And she went to the same law school as Justice Ginsburg. She graduated from Columbia Law School. I mean, it's not that you need to go to Columbia Law. I went to Tulane, and I'm very proud that I got a great education at Tulane. I don't think you have to go to a top 10 law school to get a good legal education. I think it's great for folks who do. But I bring up this point again to just note that there's just sort of this prejudice that, oh, it's a tribal court, therefore it's not capable of fairly adjudicating the rights of non-Indians. And that is a prejudice that we struggle with.
In terms of thinking about those legal prejudices and how they relate to safety and autonomy, and I'm thinking here both about women's bodily autonomy, right? Both in terms of domestic violence and sexual assault. And I'm also thinking about kind of autonomy of family, right? Autonomy of culture, autonomy of life choice, life vision. Right? What is it that people who want to make things change can and should do to try and start chipping away at that? How do you start chipping away? And I think I told you the other day, I have a lot of my students joining us today who just finished looking at the Williams case, right? Which is this very, very sad case about a child who died in part because his parents were afraid to take him to a doctor because they're afraid he'd be taken away from them. Right? How do we start chipping away at the cultural prejudices that make us think children should be taken away from their parents? Tribes can't adjudicate their own issues. And how do we institute legal protections that are going to exist no matter what the cultural prejudices are? That's a small question.
So it's a great question. And I think that's actually where I find the most value in my work as a playwright, because we can't really achieve those shifts in just writing briefs. I mean, I can write briefs until I'm blue in the face. That's not going to shift our culture. Our culture actually starts to shift when people's hearts and minds are open. And people's hearts and minds are open, and they're willing to entertain ideas of letting go of their past prejudice when they hear stories, when they connect with people, when they find humor. And so I think that actually, like, whether it's Joy Harjo's poetry, who's our first US poet laureate that's Native, whether it's Sterling Harjo, who's a Muskogee Creek writer whose show Res Dogs is about to come out on FX, whether it's a play that Delana Studi has written. She's an amazing Cherokee Nation playwright and actress. These things, I think the erasure of our Native people in Hollywood, in theaters, in K through 12 education curriculum, that has a real world impact on the prejudice. It allows that prejudice to continue. And for instance, Illuminative, in the last couple of years did some studies, and it showed that I think it's like 87% of our K through 12 schools do not teach that Natives still exist after 1900. There's just no mention of Natives in the history books after 1900. It's like this idea, we teach our kids in the United States this idea of like the noble savage who died off and is no longer here. And so there's a disconnect with the fact that we actually have sovereign tribal nations still here today. And if you don't get that education, if you go to the theater, most theaters in the United States have never produced a single play by a Native playwright. We're starting to see things in Hollywood by Native writers like Taika Waititi and Sterling Harjo and many other amazingly talented folks, and that's great. I think it's going to take a while, actually, because we're just starting to introduce it now. And so it's going to get introduced, and it's going to kind of have to saturate, and people have to absorb it. And I think once they do, they'll start seeing Native people as we really are, because they'll be experiencing authentic representations of Native people. And that will help deconstruct what is right now a stereotype and a misrepresentation that forms the basis for what most Americans assume is a Native person or a citizen of a tribal nation. So we really are working to deconstruct stereotypes. And I do think that once that is fully played out, that will make a huge difference for those of us doing this work.
So I'm going to just let the audience know that in just a few minutes, we're going to invite you to put some questions in the Q&A. You can put them there now if you like, and I'll be happy to, we're going to filter through them a little bit and make sure we give Mary Kathryn plenty of time to talk. But let me ask you then, step one, right? What is the very first thing you think needs to happen that's realistic to manage, right? What is the first step on this journey? Because obviously we can't, no one has yet made me the queen of the world. I'm suspicious about whether they're going to do that for you. Try though we might. So what is the first right thing to do?
Absolutely. So I think the first right thing to do is to, well, the easiest thing to do, well, easy, I mean, in DC, nothing's easy, but we are up against a deadline, well, not a deadline, but VAWA needs to be reauthorized. It's supposed to be reauthorized every 5 years, the Violence Against Women Act. Last time it was reauthorized was in 2013. So we are due for our VAWA reauthorization. And recently the House passed a bipartisan version, HR 1620. Democrats and Republicans both supported it. If passed into law, that would restore tribal criminal jurisdiction over non-Indian crimes of child abuse, elder abuse, sex trafficking of Native women and girls, which happens at very high rates to Native women and girls, stranger sexual assault on our law enforcement, and obstruction of justice. And so these are critical areas of criminal jurisdiction that still today, following the 1978 decision in Oliphant, and even the 2013 reauthorization of VAWA, still today, tribes do not have criminal jurisdiction over those non-Indian categories of crime. This VAWA bill would replace or would restore that. And it's stuck in the Senate right now. We're hopeful that Senator Joni Ernst from Iowa, who's a Republican, is going to work across the aisle with our Democratic friends, and specifically will hopefully work with our leadership on the Committee on Indian Affairs, because we've got great subject matter experts in Chairman Schatz of the committee and Vice Chairman Lisa Murkowski, who knows quite a bit about Indian law and Indian issues and has been a real advocate for safety for Native women as of late. And so very much hoping that these senators can work across the aisle, because safety for Native women should not be a bipartisan issue. But I think one thing that we can all do is call our senators, whether they're Democratic or Republican, and urge them to work on getting a bipartisan VAWA bill passed that adopts the tribal provisions from HR 1620. That's really the message that we need to get out there, and that this is a critical issue. And that the longer we wait, the more Native women and children suffer, and it does cost lives. So it is an urgent crisis.
Why do you have thoughts about why it is that the crisis arises, that it is at its most acute in the context of women and children, and it in some ways always has been, I think. I mean, I'm thinking about everything from, and I can't remember if this was the New Yorker profile or I read it someplace else, you know, from the rape of Sacagawea, right, to the displacement and erasure of culture by taking Native children. Why does that seem like the pivot point for where the erasure and the victimization of Indian, and here again, I mean, literally, now I'm thinking in the legal sense, right? Indian sovereignty and Indian, why is that the place where it starts and where it kind of, why is it the fulcrum?
It's a great question. I think that the conquerors who were trying to destroy and conquer tribal nations understood that relationship between sovereignty and safety for Native women. And so they exploited and used violence against Native women as a tool of conquest. So if you look at, for instance, Christopher Columbus's journals, he writes extensively, brags about raping Indigenous women, right? If you look, I mean, it is recorded history that on our Trail of Tears, the U.S. soldiers were raping our women. It was written down. This was seen as a heroic act. It was not looked down upon. It was not shamed in American culture at that time, because Americans were engaged in conquering tribal nations, and this was a tool of conquest. And I think, so, clearly we're not engaged in the exact same kind of conquest that was happening on the Trail of Tears in the 1830s, but we've never had that moment of reckoning where we've said, wait a second, that was not right. That was wrong. And in fact, we're gonna introduce curriculum in our K through 12 schools to explain that that was wrong, and we're gonna have all these conversations about it. So we haven't had that moment in the United States where we've actually stepped back and said this was wrong. And if you look at the United States Supreme Court, for instance, we still have a lot of work to do for all kinds of civil rights and constitutional rights issues as it relates to all people of color in the United States. But for Native people, when you look at what happened in Plessy v. Ferguson to Brown v. Board of Education, we still have some of our Plessy v. Fergusons squarely on the books. So, for instance, in 1821, the Supreme Court declared that tribal nations could no longer claim legal title to their lands in a case called Johnson v. McIntosh, where the Supreme Court said, literally, Indians are racially inferior savages and heathens. That case has never been overturned, still considered good law today. The Supreme Court has never said, actually, that was wrong. And when Chief Justice Rehnquist wrote Oliphant and eliminated tribal criminal jurisdiction over non-Indians in 1978, guess what he cited? He cited that decision from 1821, Johnson v. McIntosh. Now, he didn't cut and paste in the language about us being racially inferior savages and heathens, but that's what the case said, and he cited the case, and it has never been overturned. So I think that this violence against our Native women, which was sort of at the beginning, the origin story of the United States as a nation and its conquest of tribal nations, coupled with the fact that that way of thinking that racialized, oh, Native people are inferior, therefore we have the right to inflict violence on them under the law, that has never been corrected in our institutions like the Supreme Court and in our universities, in our high schools. It's an educational issue as well in the curriculum. And so I think until we see that, we're going to continue to see rates of violence against Native women that are extraordinarily high.
Yeah, I mean, there's no Juneteenth, right?
Yeah, exactly.
As long as that reckoning took, and we're far from a true reckoning, right? But even the symbolic recognition, right? There is no functional equivalent or anything close.
Right.
And so it's a hard point of insertion. We have a question in the chat from someone asking, for a student who received an education in a less than diverse learning environment, what are some resources they can use to expose themselves to Native history and issues? And I might add as well, for those who were fed textbooks that they thought were exposing them, but may not have been.
Yeah, absolutely. It's a great question. Illuminative is a great resource. I serve on their board of directors, and if you Google them, it's just illuminative.org. It might be actually illuminatives with an S, but it's illuminative.org or illuminatives with an S.org. And they have a lot of guidelines and curriculum on there to help folks in school districts who are trying to revamp these for these curricula to include accurate educational guides and information on Native people. So I think that's a great resource. I think that, so that's one thing. Two, I think we've got so many amazing Native scholars who've written amazing works on, thank you so much for putting that in the chat, who've just done amazing work on Native history and have written about it. And I think, you can go to a scholar like Walter Echo Hawk, right, and read his book, which is quite excellent. Professor Ned Blackhawk, who teaches at Yale University, has authored numerous excellent books that go through different aspects of Native history. But also, I think our artists too. If you read Joy Harjo's poetry, you'll learn about the Creek Nation's history, because she's writing about her ancestors, she's writing about her nation, she's writing about her culture. And I think, if you read Delana Studi's play, And So We Walked, it's about her journey retracing the Cherokee Trail of Tears with her father. So you're going to be learning about Cherokee Nation history hand in hand, with this play. And so I think there's a lot of education that could happen too in just reading what Native people write, is a great, I think, a great resource.
I was muted, sorry. I've tried as quickly as I could to put some of those resources in. I think I missed one, but I'm sure you'll tell me what it is and we'll add it. But for folks who'd like to look for the attendees, I've listed some resources, some links to some of the folks that Mary Kathryn just recommended in the chat box. We have another question. I'm just going to read this one. I'm currently a Native secondary educator teaching non-natives. How can I contribute to this work in my current position? My undergrad was in American Indian Studies, and I wish to go into Native law, working toward protecting women and keeping families together.
Oh, I love hearing that. We need more Native attorneys, and it's a real calling. It's a service. It's not easy. It's hard work. It's very hard work. There's a lot of we lose a lot of cases in federal courts. I mean, I was working on the adoptive couple versus baby girl case that was in the Supreme Court in 2013. It was a very disappointing case for my nation, Cherokee Nation, and the family, Deason Brown, who lost his daughter. You had a Cherokee family split apart by a Supreme Court decision. Very tragic. These are tough fights to fight. But I think for a lot of us who really look to our ancestors who made it possible for us to be here today, I think we also understand that it's an honor to do this work, because if it wasn't for them, we literally would not be here today. And so what is it that we have to give back so that the future generations will be here, right? Because we're somebody's ancestor. And so I think that it makes this work very rewarding in ways that aren't always tangible or monetary. Although, there are lots of ways to make money doing federal Indian law. It's not like you can't get paid, but I will say there's a huge need for pro bono Native work. I can't tell you how many phone calls I get a week from family members from families whose daughter, niece, sister, mother, cousin has been murdered, and the law enforcement's doing nothing. The feds aren't investigating, the state is not doing anything, and they need the help of an attorney. And we're a small law firm, and honestly, I get to the point where I can't do it all. And so I have to say to some folks, I'm sorry, we don't have the staffing to take this on right now. And I just wish we had more folks who were available to help our families in these kinds of cases. There's a lot of cases too where states are still coming in and taking Native children from families. So your instinct to go to law school is a great one. And we have so many great Native law programs today. And also ASU has a great program, OU has a great program. Folks go to schools like Cornell and Yale and Harvard and Stanford and study federal Indian law. I mean, there's just lots of ways to study federal Indian law. I went to Tulane. Tulane did not have an Indian law course, but I took critical race theory, and I worked with my professors to work on Indian law cases and research them and write about them. And, law school is an amazing time to study certain areas of the law. It's also a great opportunity just to learn about the law. And I will say that, you really can't go wrong with choosing a law school that you're excited about and working with professors that you're excited about. And there's so much in federal Indian law. You're looking at administrative law, which pretty much every law school teaches, right? So, really admin law is probably, if you really want to do federal Indian law, that's maybe one of the most critical courses to take. Environmental law has a lot of overlap. And I was very blessed to have a professor, Oliver Houck, who understood that overlap and who taught some of these Indian law cases like Johnson v. McIntosh in my environmental law courses. And so I just would encourage you to go to law school. It is a sacrifice, especially for those of us who maybe can't fund our entire education and have to take out loans or get scholarships. But I think it's a very worthwhile thing to be able to come back and serve your nation and to serve Native people and to work on these issues.
Well, thank you for that. I'm reminded as well, as you said, that law school clinics and externships are also a great way to get your feet wet and see if which kind of practice might suit you best. And they often lead people as well to careers. I'm thinking about actually a former clinical student of your professor at Tulane, your environmental law professor, who has since gone on, and who's not a Native lawyer, who's since gone on to represent tribes in Louisiana in the BP litigations, right?
Yeah.
And that was an experience that was cracked open for him by that kind of teaching of environmental law, right? To think about its nexus with the damage it does to Native communities and Indigenous peoples and environmental justice. We have another question here. I often hear that non-tribal members are involved in making decisions for the tribes they do not belong to. Assuming this is true, why is this? Is this an issue that the Native community is trying to overcome? And I assume here they're talking about more than simply who gets to vote at a council, but they're asking about.
That's an interesting question. I think it's hard to answer that without a little bit more specificity in terms of the example that you're thinking of. But I do know that, a lot of tribes hire non-natives or non-tribal citizens to perform different roles. Sometimes tribes will hire a non-Indian to be their attorney general. Sometimes, if the president or chief or, of the nation appoints a non-Indian to be the attorney general, or sometimes they'll hire non-Indians in all different kinds of capacities, because even though tribes do like to hire, give job opportunities to Native people, they're also just like any other government, they're out there hiring the best folks who are around. And sometimes there's a great non-Native person who can be of great service to a tribal nation. I'm not sure the exact circumstances that you're thinking of here in terms of a non-Indian sort of dictating what happens with a tribal nation. But, I do know that there are also instances of non-Indian corrupt influences with our tribal nations. And that's something that we take very seriously and, encourage the FBI to investigate when that happens. And I also know that there are some tribal leaders who hire non-Indian advisors. And I think that, um, just like I may not agree with all of President Biden's advisors, I may not agree with all of the advisors of the leadership of my tribal nation, and that's okay. I mean, that's part of the political process. And so, again, I think we just all have to advocate within our own political process for our leadership to make the decisions that we think would be best for our nation.
So we are getting questions fast and furious, and I also promised that I would offer Mary Kathryn the last few minutes to say anything that she thinks needs to be said. Can I give you kind of Cliff Notes versions on the couple of questions we have remaining, and then I'll turn the floor over to you?
Yes.
So we have 3 questions. One is a resource question. Where can we get some resources about the horrors of boarding schools for Native Americans? And I think probably we can work on getting a list of those resources from you or from elsewhere. We have some resources internally, and we can email those out to people who participated, unless you have something in particular.
I would say one author, and I'll put it in the chat if I can figure out here to do all oh wait, hold on. I gotta do panelists. And Brenda Childs is her name, and she's an Ojibwe author and historical scholar, professor, and she has done excellent research on boarding schools and written many books. So I would recommend her books are a great place to start.
And then we have 2 other questions, one centered in law school and the other centered in narratives, but I think they speak to each other. One question is, what thoughts do you have on how law schools teach the problematic cases, black letter cases like McIntosh, which shows up in this writer's as a short footnote in a property textbook. What do students and professors, and I think the burden here, frankly, is on professors, who can be expected to understand their note cases, right? It's not a student's burden to go read the note cases and go pull a whole opinion. What can professors do to teach those cases better and to do a better job addressing the issues? And outside of the law school context, kind of the last question that I'm going to raise is, what are some narratives that criminal justice advocates inside and outside of law school environments need to adopt or adapt to be responsive or inclusive of Native issues, especially where the narratives of movements may diverge from awareness in Native issues? And here, what I think we're talking about is the fact that the abolition conversation, for example, abolish the police, has resonances that simply don't necessarily speak in the same way to the sovereignty crisis. And so those are, I guess, two separate questions, but they deal with this question of mediating narratives, right? Legal narratives that come from one lens through a Native lens.
Yeah, absolutely. I think that for that last question, I will say that I get asked this question a lot, and I very much, I'm a huge ally in terms of and support very much Black Lives Matter. I think that movement is critical. I think not only is it critical that we as Native people support that movement, but I also truly believe that when we work together to deconstruct any system of oppression or racism, even if it's not specifically tailored to our own people, that working in allyship with others, that actually benefits everyone who's marginalized. I truly, truly believe that. I think we have seen the benefit of these race conscious discussions that have emerged because of the movement of Black Lives Matter that has raised the awareness about Native people for non-Native folks as well, to say, wait a second, maybe we need to stop looking at Native people as invisible and start seeing them and talking about them and thinking about the consequences of our actions and political systems for Native people. And so I think with that in mind, I will just say that, yeah, our crisis is very different. We do have Native people are brutalized and murdered by law enforcement, state and federal law enforcement at very high rates, just as African Americans are as well. But for us too, we have this crisis where our women and children are being murdered in their own communities. And we've been told that our governments don't have the authority to protect them, and the authorities that do aren't using their authority to protect them. And I think at the root of it, it's the same kind of racism. It's a devaluation of the lives of Native women. It's a decision that when a Native woman or child is murdered, it doesn't matter because her life is not valuable. And so I think that actually, even though we're talking about solutions that sound like they're in opposition, they're really not, because what we're talking about at the end of the day is valuing the lives of our people. Right. And so that's where I think we really do come together, and that the, missing and murdered Indigenous women and girls movement is not at all at odds with the Black Lives Matter movement. I think they're really hand in hand. And I've seen folks on both sides support one another in really beautiful ways. And what was the last question?
The other question was about what is it that law professors need
Oh,
to
yes.
do, and law students to tackle these issues in their classrooms.
Yeah. And I think, I think asking questions is so important. Like, well, what do we think about this? Do we think it's appropriate? What is the legal justification for declaring Native people to be racially inferior? And so with all of that in mind, sometimes too, though, I've had professors say, well, I'm not Native and I don't have any Native students in my class. What do I do? And I think, we've done so much by Zoom during the pandemic. Invite Professor Angela Riley, to speak in your law school class. I mean, I just gave her as an example, but we've got a lot of Matthew Fletcher. We've got all these different Native law professors out there that are teaching at very specific law schools that could, they may not have time to zoom into 100 different classes every year, but you can also ask legal advocates and practitioners to come and speak to your class, and that can expose your students to another lens on some of these cases.
And I'll add my own little plug, which is just that I think law professors have an obligation to be thoughtful about these issues when they choose their textbooks. I'm just speaking out of my own experience, but I think long and hard about what are the cases that people have chosen to put in the textbooks, and are they telling the stories, or at least deconstructing stories in ways that tell truth about history rather than simply pushing concepts. So the last 10 minutes are yours. What would you like to talk about? What do you want to say? What's on your mind?
Oh, thank you so much. I just really appreciate the chance to share all of this with everyone here today, because, we are facing a crisis here in Indian country in terms of the rates of violence against our Native women and children. And we need everyone to help us in this fight to restore tribal sovereignty and jurisdiction. And we need everyone to help us hold police and law enforcement accountable when they're not prosecuting these crimes, when our Native women and girls are murdered or go missing, and the feds and the state law enforcement choose to do nothing because they don't value the lives of our Native women and children. And so we need you to support that. We also need people to advocate for law schools to hire Native law professors to teach federal Indian law, so that these courses are offered. And so that when someone goes and clerks on the United States Supreme Court and they get an Indian law case, it's not the first time they've been confronted with federal Indian law. We need our federal judges to hire Native law clerks, and we need to support our Native artists because they are doing that work that's going to change the hearts and the minds, and that is going to combat the prejudice that exists out there that does hold us back in this harmful legal framework. So I just really appreciate everyone taking the time to ask these questions, to ask for resources, and to do that follow-up research and to educate ourselves. I just really, really, really appreciate it. And thank you so much for the time that we were able to spend together today.
Well, I thank you. This has been such a treat. And it's amazing what you do, and it's amazing to have the chance to talk to you and reconnect. I want to point out to everybody that we put some information in the chat. I think we've got Matthew Fletcher's information up. If you want to try and look at some other resources, I think Turtle Talk is a great resource. The Turtle Talk blog, and I think that is Matthew's, right? That's
yes,
Professor Fletcher's resource.
Yes.
And for those of you that are interested in kind of following up more on the legal issues, there is something up, I think, on our YouTube channel about a conversation we had with Professor Fletcher, Julie O'Connor from the Federal Defender in Oklahoma, and a couple other folks who came and spoke with us about McGirt and McGirt decision and what was coming down the pike with cooling. And so for those who want to kind of unpack the legal issues, the jurisdictional issues, the Major Crimes Act pieces, that technical information is also available. It's tricky, I think, to unpack all those issues. But those resources are available. I guess I will also point out to those who are perhaps joining us for the first time that this series, and I just can't tell you how much it means to have Mary Kathryn join us, is a piece of our effort at the center to really try to dig into the ways in which small tribal and rural criminal legal systems have been left out of this national criminal legal reform movement. And so the vast majority of our narratives about criminal legal systems tend to be about urban communities, and primarily told in stories about Black and white, primarily told in stories about white and Hispanic. We tend not to think about the problems of scale and distance that confront small tribal and rural communities. I'm reminded here of a project going on in one Native community where they innovated and put together a justice bus. It's a mobile home that went out all over, thousands and thousands of acres, to serve Native communities on low-level offenses, so they didn't have to come into courts, right? And the extent to which we are as a criminal legal reform movement, not only neglecting issues and crises in these communities, but also overlooking some of the really wonderful innovations and successes that they've had. And there are some wonderful examples, for example, of restorative justice, particularly in the juvenile justice space in tribal communities, where we're seeing results that are very different than what we see in specialty courts in traditional US jurisdictions. Right? And by bringing folks like Mary Kathryn and really just having her tell us about her amazing work and the way she thinks about these issues, part of our hope is that those of you who are joining us will help us make it clear that you can't have a national criminal legal reform movement if you're not including everyone. And that means including small tribal and rural communities, and in particular, being thoughtful about the ways in which dual jurisdiction, right, and sometimes triple jurisdiction, right, where you have state and federal and Native jurisdictions competing, are important, complex legal problems, and we can't walk away from them as a criminal legal reform conversation just because they are hard. And yeah, they're hard. They're choice of law. Sorry, you got to take the class. But it's a real gift to have somebody who has practiced in the field and whose life's work is storytelling. Right? Storytelling in the courtroom, storytelling in the theater, storytelling in advocacy across all those different venues. It feels to me like what ties it all together is your wonderful gift at telling stories.
Well, thank you so much. I really appreciate it, and it's been an absolute honor to share this time with you all. And I apologize that I do have to run. I have to get down to I'm at this conference and there's another panel I have to run off to. So I apologize that I have to end it now, but thank you so much for having me today. I've really appreciated it.
Thank you. Go to your meeting. We really appreciate it. Thank you all for joining us. Let me just remind you that if you would like to subscribe to our listserv and get information about future events in our STAR series, or you'd like to be able to access some of our resources online, please, you can send an email to us at Deason Justice. I can't even talk. Look at that. Deason Justice Center at smu.edu. And we'll be happy to add you to the list. You'll be able to have prompt access and without having to search online for our videos, check out our resource lists, and be on our mailing list for future events. We do hope to have another in this series as the Supreme Court continues to look at these issues. So thank you all very much for joining us, and we will look forward to seeing you next time.